Your Lordship, I seek your indulgence in mentioning item number 13 of the hearing list. I have taken the consent of the petitioner's advocate, and if the matter may kindly be taken up after vacation, Your Lordship.
Please write down as paid for Mr. Victor. As paid for by Ms. Louis Learned Government Advocate, appearing for the state respondents and not objected to by the other side. List the matter again after the vacation on a date to be fixed by the registry.
Much obliged, Your Lordship.
For motion, item number 1.
Mr. Ramzawa, I think you have challenged the rules.
We have challenged the rules, Your Lordship.
So this has to be laid before the decision bench.
In spite of that, Your Lordship, there is the WPC number 31 of 2020, that's PIL, filed by the Central YMA over the same subject matter, but we have failed to mention all such things. I think it is in the interest of justice if Your Lordship permits us to withdraw this and file afresh.
Please write down as paid for by Mr. Seela Ramzawa, Learned Senior Counsel for the petitioners. The writ petition is dismissed as withdrawn. Stop. However, liberty to file a fresh writ petition is allowed as paid for.
For orders, item number 9.
Lordship, in spite of the fact that I had sought for time for filing of additional affidavit, Lordship, I have not been able to. So, under the given circumstance, Lordship, if permission, time is granted to me.
How much time do you require?
A week's time, Your Lordship. It may be listed after vacation.
Mr. Lianshima, any objection?
Well, the learned counsel for the applicant knows very well the fact that the applicant has approached this honorable court after 8 long years, my lord, and no justification in the application itself. So I don't see the reason why it should be granted more time. Anyway, my lord,
That makes
up
it
to
all
your
the
lordship.
more necessary, Your Lordship.
Then the matter may be listed after vacation, my lord.
You
In
have
the
filed an IA
coming
for
week.
condonation of delay,
Yes, my lord.
Yes.
and you want to file some additional documents
Additional
to
affidavit.
take your to help your stand.
Your Lordship. That's what I had sought for during the last.
Last chance. Last chance.
Yes, Your Lordship.
Mr. Seela Ramzawa, Learned Senior Counsel for the applicant, submits that although time was granted to him, but due to some difficulty, he could not file the additional affidavit as was allowed. Stop. Mr. L.H. Lianshima, Learned Counsel for the opposite party, submits that there is no merit in the application, and in fact, the same should be considered at the earliest. Next para, having regard to the submissions made, Mr. Seela Ramzawa, Learned Senior Counsel for the applicant, is granted a week's time as a last chance to file additional affidavit. To stop. Next para, list the matter again after the ensuing puja vacation on a date to be fixed by the registry.
Your Lordship.
Item number 10.
Yes, may I please, Your Lordship?
Oh, is here. Yes.
Yes, Lordship, this is an application for condonation of delay.
Your,
Yes, and
your internet
yes.
is working properly today?
Yes, yes, it's
Okay.
stable now, Lordship. Yesterday the server was down.
See, I think the IA has to be heard.
Yes, yes.
Can we have it after the admission matters? Because
Yes,
this might
Lordship,
take some
no-
time.
No problem. Yes.
All right. Pass over for the time being.
Item number 11.
May it please your lordship, Mr. Bilara Menga has informed me that he will be appearing for the respondent.
Yes, Lordship will be filing our Vakalatnama by today. We'll be filing our Vakalatnama today. In the meantime, may we be given time to file a written objection?
How much time?
2 weeks' time.
Mr. Zoram Chana, learned counsel, appears for the applicant, and Miss
Lalmun Moyi.
Lalmun Moi, learned counsel, submits that she has instructions to appear on behalf of the sole respondent. Full stop. She submits that she will be appearing along with Mr. B. Lalramega, who will lead in the matter. Full stop. She prays that she may be given 2 weeks' time to file her power as well as the objection to the IA. Prays aloud. List the matter again after 2 weeks.
Obliged, my lord.
For admission, item numbers 2 and 3.
Your Lordship, on behalf of the state respondents, the affidavit in opposition has to be, we're waiting for the Undersecretary to sign the affidavit. So, Your Lordship, kindly a week's time may be granted to file the affidavit in
The
opposition.
affidavit is ready.
Yes, Your
otherwise-
Lordship. Yes, Your Lordship.
How much time? 1 week?
Yes, Your Lordship.
Mr.
It may be taken up on 17th, my lord, October.
What about, have you received the affidavit?
Not yet, my lord.
Thing is that you might want to file a reply to that.
In fact, my lord, in the analogous case, the other case, item number 3, they have already filed. I believe that the rest will be one and the same.
In item 5? No, this is listed with item 3. This is
3.
WPC 60 of 2023.
Yes, my lord.
Last time, Ms. Dinari had said that it's similar.
Yes, my lord.
That's why we had listed this
Yes, my
also.
lord.
There's another item apart from this?
No, my lord. I mean to say item number 3.
Of
In
course.
item number 2, they are yet to file their affidavit.
Okay. She wants 1 week time.
Yes, my lord.
We'll grant. And you want it on a specific date?
If possible, my lord.
That is
17th of October.
17. All right. Mr. Victor L. Ralte, learned counsel, appears for the petitioners S. And Ms. Lal Nunlui, learned government advocate, appears for the state respondents and submits that the affidavit is ready and will be able to, and she'll be able to file the same within a period of 1 week. Full stop. In view of above and as prayed for, that's the matter on 17th of October 2024 for admission.
Much obliged,
Deeply
Your Lordship.
obliged.
Item number 4.
Lordship, this morning I have filed my rejoinder affidavit upon the affidavit in opposition filed by the respondent number 4 and 5.
Ms. Jacinta Zouthanmoi, learned counsel for the petitioners, submits that she has filed the rejoinder affidavit this morning. Stop. It is, however, seen that the same is not on record. The registry shall verify and connect the same to the case record. List the matter again after the ensuing puja vacation.
Mr. Place.
Item number 5.
Yes.
Yes, Your Lordship. I'm appearing on behalf of the respondent number 6, DC Scholarship District. My Lord, if I may be given another 2 weeks' time to file affidavit in opposition.
You were given 3 weeks' time last time.
Yes, my Lord. The supervised comment is still pending in the law department for vetting. The same has not been received by us.
What is the matter regarding?
It's about damage compensation.
Sorry?
Damage compensation.
Damage compensation, for what? Who has damaged your land?
The petition is respondent number 1 to 5.
How was your land damaged? By whom?
The railway,
Sorry?
for the railway. for the
Please speak up, don't be nervous. Speak up. What is your prayer?
To pay damage compensation.
Damage compensation for damages done to your land? By
Yes,
whom?
Lordship.
Construction
by
of
the
railway
railway.
line?
Yes, Lordship.
Okay. And who has filed affidavit so far? Respondent number 5. Who's respondent number 5?
Deputy Chief Engineer. Deputy Chief Engineer.
Who is representing respondent number 5? CGC?
No, I think the CGC represent 1 to 4.
1 to 4.
No.
So there is no affidavit. 6 wants some time to file affidavit. That's the Deputy Commissioner Kolasip. What about the others? 5 has filed. Are you there in this case, Mr. Zainab Sampui?
My lord, I'm seeking some more time for filing the affidavit. In the meantime, the counsel for the opposite party submit before the court that the similar case has been pending before principal seat.
What is
Then-
that case? What is the case number?
That was submitted by the counsel for the petitioner, my lord.
When? Please write. Claim of the petitioner is for damage compensation due to construction of railway line through their land. The respondent number 5 has filed counter affidavit, but the remaining respondents are yet to file the same, as paid for by the respondents appearing for, learned counsels appearing for the respondents, except respondent number 5. Further 3 weeks' time is granted as paid for to obtain instructions and to file counter affidavit. Next para, it is said that a similar case is pending before the principal seat at Guwahati. Stop. The learned counsels for the parties shall inform the court the particulars of the case which is pending in Guwahati by the next court date. List again after 3 weeks.
Item number 6.
Yes.
I have filed my affidavit in opposition on behalf of the state respondents number 1 to 4.
1 and 2.
1 to 4, my lord. 1, 2, 3.
How many respondents are there in all? Yes, 4 only.
4, yes, my lord.
Mr. Ramzawa, what do you want?
May I like to file a reply affidavit?
How much time?
Which time, Lordship?
Ms. Caroline K. Lung Oipui, learned government advocate appearing for all the respondents, submits that counter affidavit has been filed by the respondents. Stop. Mr. Seal Ramzawa, learned senior counsel appearing for the petitioner, submits that he may be granted 3 weeks' time to file a rejoinder affidavit.
3 weeks.
The prayer is allowed. List the matter again after 3 weeks. Meanwhile, the petitioner may file rejoinder affidavit if so advised.
Item number 7.
Otherwise, Your Lordship, no affidavit has been filed by the respondents till date.
Where's Mr. Samuel? Samuel Banarchieta. He's on legs. He was supposed to produce the GCC, General Conditions of Contract. Just get in touch with him. We'll take it up after some time, Mr. Ramzawa.
Right.
Passed over for the time being.
Item number 8.
My lord, I have not yet received Paraguay's comments in this matter. I am appearing for respondent number 5, 6, and 7.
My lord, I am appearing for respondent number 1. I seek another 3 weeks time for obtaining instruction and for filing an affidavit.
My lord, respondent number 2 returned unserved. Respondent number 2, NHIDCL New Delhi. I think the address is incorrect.
Why don't you serve by Dusty? Address is Tui Khot Lang.
My lord, Tui Khot Lang, they have received.
1710.
Tui Khot Lang have received. Respondent number 3.
Then number 2 is what? Delhi.
Yes, my lord. We have the new
So
address.
why don't you get the proper address from
Yes,
the respondent number 3?
We have, my lord.
You have got it.
Yes,
So what will you do? You'll take first steps.
my lord. We can take it.
Now, who's appearing for respondent number 3? How did you serve notice?
We have served notice, my lord.
How?
By registered post.
Please write down. Office note dated 10/9/2024 indicates that AD card has returned back from respondent number 3. Stop. Accordingly, notice is accepted to be complete on respondent number 3. Next para. Office note dated 24/9/2024 indicates that unserved notice in respect of respondent number 2 has returned back with the postal address, with the postal note within inverted comma, shifted, comma, left, then RTS, close inverted comma. Stop. At this stage, Miss Mercy Lalsiat Tluangi, Learned Counsel for the petitioners, submits that they have ascertained the correct address of the respondent number 2 and prays that she may be allowed to take fresh steps upon them, upon the respondent number 2. Stop. Prayers allowed. Let fresh steps be taken on respondent number 2 in the correct address within a period of 3 days. Next para. Ms. Zarem Sangpui, Learned CGC, appears for respondent number 1, while Ms. Caroline Kelung Oipui, Learned Government Advocate, appears for respondent numbers
5, 6, and 7, ma'am.
5, 6, and 7. And they pray that they may be given 3 weeks' time to obtain instructions and to file counter affidavit. The prayer is allowed. What about number 4?
ID card is not returned till date, my lord.
Not returned.
Yes.
You have taken steps?
Yes, my lord.
List the case again after 3 weeks. Office shall track the postal consignment of the notice sent to respondent number 4 and put up a note by the next date.
Oblige.
For orders, item number 10.
Yes, Lordship, this is an application for condemnation of 686 days delay, Lordship. And judgment and order date is 28/1/2022. And the concerned department received it on 14/2/2022.
Ms. Malswamy, please
Yes.
go slow,
Yes,
slow and steady, since you are online, so we'll have to take
yes,
care of
Lordship,
that.
Lordship.
686 days delay. Judgment is 28/1/2022.
Yes.
Copy received by the
Department
Department on
by the state government on 14/2/2022.
Okay, then
And Lordship, necessary steps were taken by the government in order to comply with the judgment and order. The judgment and order directed the state respondents to pay rental compensation of rupees 83 lakhs.
okay, what are the steps taken?
The steps were taken in order to comply. Some spot verification were taken, Lordship. Although I have not mentioned it in my statement in the application, but however, steps were taken. And Lordship,
No,
what
how
I
can
would
you-
like to submit is that
Just a
Lordship,
minute.
it was on time.
Just a minute. You also have to listen. See, you said that steps have been taken to comply, but You have not mentioned that in your application. So you are
Lordship,
submitting
in
from
my-
you're submitting from your general knowledge.
Lordship,
is-
in
that is not
page 3
possible.
of my application, I have mentioned it, I have made a statement that steps have been taken by department in order to comply with the judgment and order.
Where?
I have made a statement in page number 3, para number, Roman number 1. The last para, last line.
That is only a statement, but what are the steps?
Yes.
You
The
have not,
steps taken is that, Lordship, even the DC has made an assessment, and that was being forwarded to the department. And Lordship, what I would like to submit is that at the time when I'll come to that, Lordship. If I don't submit it step by step, I'll just confuse your Lordship. So,
so don't confuse me then. You go step by step.
I'll go step by step, yes. On 18/2/2022, that is on page 33 of annexion number 2, this has been, the assessment was forwarded
Just a minute,
to
just a
the,
minute. You both
Yes.
can go and type it out. You are saying 18?
18/2/2022.
This is annexure.
That is on annexion number 2, yes, page number 33 of my application.
33, okay.
Yes. This is a letter forwarded to the Director, Higher and Technical Education Department by the Mizoram Polytechnic Lunglei, Principal Mizoram Polytechnic Lunglei. This is stating that this is the rental charge, the assessment made by the DC Lunglei.
Yes.
So they have requested the Director, Higher and Technical to make a payment of the rent as per the judgment and order.
Okay, then?
So the next page, page number 34, is the assessment made by the DC, Lunglei district. 34 and 35 is the assessment.
Okay, then?
Yes. On 22nd February 2022, the Director, Higher and Technical Education Department again forwarded it to the Undersecretary, Higher and Technical Education Department, ISOL, the assessment which was received by them. That is on page number 36. And Lordship, steps has been taken, although there is no statement with regards to that. But however, on dated 33/2022, a joint meeting was held by the government whether to comply with the order or to file an appeal with the meeting of Higher and Technical Department, Law and Judicial Department, Land Revenue Settle Department. All those, they have the joint meeting on 33/2022. And on thorough discussion, they have decided that an appeal be preferred to the Honorable High Court.
Decision was
And-
taken on 33/2022.
On 33 to, yes, 2022. And Lordship, on 12 April 2022, a request was made to the Additional Advocate General, ISOL, to prefer an appeal before the Honorable High Court. That is on page 39 of my application.
Okay, one question.
Yes,
Meeting decided on 33/2022.
yes.
Okay, letter on 12/4/2022.
12/4,
Within-
2022, yes.
Within 12 days.
It was within, yes, it was within time, Lordship. When the department forwarded the letter to prefer an appeal to the Additional Government Advocate General, it was still within time. It was after 75 days. It was well within time, Lordship.
Then?
So, but however, Lordship, in my statement, I have made that since there was a misplace of the documents, I have already mentioned this in the other appeal also. There was some rearrangement in the office, so some documents were misplaced at that point of time. So I've made a statement to that, Lordship, in my application,
Where is your statement?
that there was a misplace of documents in the office in page number 4, Roman number 4. And it was endorsed to the present government advocate, Lordship, and that was not known by the present advocate. And on 16/5/2023, Lordship,
How do you say
when
that
the
it was
state-
not known to you?
Lordship, I've sent a letter to the department also with regards to that.
You all sit in one
On-
office. You don't have different offices. You all sit in one office. How do you say that you don't know?
Yes, we all sit in one office, but there was a Lordship endorsement was made from the additional advocate general, and it has been we're not sitting in the same room, Lordship. It has been endorsed to me, but
I did not
it
say
was
you
not
sit in the
known to
same
me.
room, but you sit in the same under the same roof, in one office.
Yes.
Correct.
There
Now,
was some rearrangement in the office, and some files were misplaced at that point of time, Lordship.
misplaced.
So I've made a I've sent a letter, and on 7 June 2023, when the status of the appeal was asked by the department whether an appeal has been filed or not. So in reply to that, I've sent a letter to the department on 7 June 2023. That is on page 41 of my application, annex number 7.
Just a minute. The department inquired about the status on 16/5, correct?
Yes.
16/5
12.
of which year?
2023.
Oh. What happened to more than 1 year in between?
Yes.
See, the letter was written to the AAG on 12th April 22.
2022.
2022. Now, after 1 year, more than 1 year, they come and inquire about the status of the case. Then you
Yes.
say that
It was when
how do you believe all these things?
Lordship, even some correspondence was made after that. In the letter dated 16 May 2023, there was a reference letter that is on 12. There was also 13/4/2022, 10/5/2022. There are letters here. But this, I have made a clarification in my letter also in page number 41, saying that this other correspondence has not been received by the said office. The government think that when the request was made to the additional advocate general to file an appeal, they thought that they have the appeal was already filed at that point of time. So after 1 year, yes, they have requested the status report of the appeal. But however, due to some misplacement and reorganization in the office, there was some documents were lost. So on thorough search, we have found out the previous letter that is dated 12/4/2022, and the present government advocate has sent a letter back to the Deputy Secretary, Higher and Technical Education Department, and said that appeal will be prepared soon. And also that they have not yet furnished the correct certified true copy of the judgment and order. So she has requested also, and that also some court fees were
No,
also
please read
requested
your
to-
letter. Please read
Yes.
your letter at page 41
Yes.
with reference.
With reference to the subject cited above, an appeal against the judgment and order dated 28/1/2022 has not yet been filed as of date due to the reason that the documents already furnished to the Office of the Advocate General was misplaced as there was a change of record room in the office. However, on thorough search, it has been found out recently in that other correspondences except letter number so and so dated 12/4/2022 have not been received by the office. It is also pertinent to mention that steps have been initiated by the undersigned to file the appeal as soon as possible, and on going through the documents already furnished, white letter dated so and so dated 2/12/2022, an original certified true copy was not properly stamped, and ad valorem court fee of rupees 11,000 are required in order to file an appeal. I therefore kindly request you to do the needful and furnish the same to the undersigned at the earliest.
So,
So
let me speak. Just listen.
yes,
So your letter says that you have received the letter of 12/4/2022.
yes,
That was 1 year before your letter. So one
Yes.
whole year, nothing was happening. You misplaced the record, or you have changed the
No,
record
Lordship,
room.
the endorsement was never known by the present advocate. On
How
that
is-
day,
how is that
only this
possible?
letter, 12,
How is that possible?
Lordship, some file has been misplaced in the office. That is the reason why I've stated in my application also. And in other appeal also, I believe it was in the last week also, I've stated this statement in my other appeal.
In your
that
other appeal,
there
what
was-
you have,
yes.
listen, in your other appeal, what you have stated is that the records, the data in the computer got lost because your computer got spoiled.
No.
Today you're saying your record is misplaced.
No, in that application also, I've made this statement, Lordship. I've made a statement that some documents were misplaced in the office.
No, this is very
So
serious. This is very serious.
Yes.
See, department says that this is the case, we want to file appeal. And then you go on misplacing the records. This is very serious. Who will
Yes,
be
Lordship.
responsible for this? Somebody has to take the responsibility. How you organize your office, how you organize your establishment is up to you. Court has no role in that. But the thing is that when something has to be done within a specific time frame, it has to be done. You cannot just casually say that it was misplaced, it was not there, we did not receive. You should invite the officers concerned to your office. Sit down, have a discussion on the
No,
matter.
Lordship,
Get the
this
files.
letter to
What is this?
this le-
Just listen. What is the issue of writing letters after letters? You're not staying in a different city altogether. You're in the capital of the state. You invite the nodal officer, ask them to come over, have a discussion, get the files, get it done. Not just write letters like that, you see. Because the thing is that you're dealing with court case. You're not dealing with the normal routine office cases. There's always a time frame. If you don't file your appeal or your review or whatever you have to file within the time, then whatever merit you may have, they'll be useless. You'll get dismissed. So you
Yes,
all,
Lordship,
you know
but-
very well about these things.
yes.
So you cannot just say that it was misplaced like that. Then now let us
Lordship, but
proceed.
I'm
Let us proceed. After you say that it's misplaced, how have you conducted? Next,
no,
what happened?
Lordship, this endorsement, yes, was never known to the present government advocate.
Okay, you've
since
said
it
that
was
already.
Never, yes,
Not known to you, but
So-
now you know it, isn't it?
was not known. Yeah, now I
7th
know
of June,
it from
7th
June
of June 2023, you know it.
2023. Yes, I know it. And then
Then you filed the appeal in
request to-
14th of March 2024.
Yes.
How do you explain that?
Lordship, I'll come to that. Yes. On 9 June 2023, and this was a letter that is on page 42 of my application. This was a letter by the Deputy Secretary to the Assistant Government Advocate, Lunglei District, to obtain the original certified true copy of the judgment and order.
Let me tell you one thing.
Yes.
You may start your drafting with the true copy or with a Xerox copy of the judgment and order. You need not wait for the certified copy. And you can file the Xerox copy before the court by informing the court that please give me liberty to file a Xerox copy. And I will undertake to file the certified true copy in original when I get a copy. That can be done. You cannot just say that, send one letter there and say that wait for the original copy and wait for 2-3 months to get the same back. In the meantime, everything is delayed.
Yes. Lordship, some drafting were done at this point of time, Lordship.
So what drafting was done?
Yes,
Let us see.
But however, on going through all those documents, there were some illegible documents also, some lower court records needed. Even all those evidence needs to be read, Lordship. Some research has to be done in that case. And moreover, this was not the only appeal to be filed. As I was saying in my other appeal also, there were other cases which need to be appealed. So this is not the only case with the present government advocate has been drafting at that point of time, Lordship. So on 14 June 2023, the certified true copy was sent to the present government advocate.
So just 5 days only.
Yes.
Within 5 days, you
in
got
my
it.
statement, yes, in my statement, I've made that the drafting begins from the month of July
Of which year?
of 2023.
Drafting started in July 2023.
Drafting, yes,
And drafting completed in
2023.
after 1 year. How can you believe
Lordship,
that?
I'll come to that, Lordship. As I was saying, Lordship, even some research need to be done. So, moreover, there was some other, this is a second round of appeal, Lordship. There was a first round of appeal in the merit of the case also. So, some research has to be done. And moreover, some documents were refurnished again.
Yes, what is
And
that
that has
research
taken
you've
time.
done? What is that research
That
you've
was,
done?
yes, that was on the part of the government advocate, Lordship.
You tell us what research you've done.
Lordship,
What sort of research did you do?
Lordship, in
The
case,
department did
Lordship, I
not
have
give
to
you
do
the
some
grounds of
research.
appeal.
In order to file an appeal, yes, we have to take we have to read all the written statement made by the government in the trial court also, Lordship. We have to do some research in order to file an appeal before the Honorable High Court, Lordship.
I
And
understand.
moreover, we have to draft the grounds also. We
No,
have to
that we
take-
understand, Ms. Malswamy, we understand. The reasonable time is required to prepare the appeal,
Yes,
but not
yes.
more than 1 year like that. See,
Lordship,
you've got
yes,
the
I'll come to
materials.
that, Lordship.
No, you've got the materials in 2023, June.
Yes.
You filed
I'll
your
come to
appeal
that.
in 14 March 2024. So is it such a very big and tough case that you do research for almost 1 year?
No, Lordship, there was a part of some personal difficulty with the government advocate also, some medical conditions. So on the month of October, as I was saying, Lordship, there was some technical difficulty in the laptop of the present government advocate. So all the files were gone and it could not be retrieved. I've made a statement in my other appeal also, this one.
Don't rely upon the other appeal,
reasons,
okay?
yes.
This will stand on its own merit. Just because some sort of liberal
No,
consideration
What
was
I'm
done in the
saying-
other appeal, don't think that this also will be the same thing.
no, Lordship, what I'm like to submit is that, Lordship, this is a bona fide reasons. That is what I'm trying to say.
Bona fide
It was,
reasons have to be explained bona fidely.
Yeah.
Where is the explanation?
yes.
With 4 paragraphs, how do you explain the delay? This is
And
the thing.
Lordship,
When you can take 8 months to draft an appeal, how do you file 4-paragraph application for condonation of delay in the first place? See, court is very liberal. Number of days, no matter. 500 days, 600 days, okay. But there has to be plausible explanation, proper explanation. That's the thing. Otherwise, even if it's for 50 days delay without any explanation, court will not condone it. But if it's 600 days with proper explanation, court may consider it to condone the delay. In your case, you have made your drafted, your application is quite sketchy, as it seems. Because you have not mentioned what is the reason. You say that we were in the process of complying, but there is no material to substantiate that.
and
Apart from showing me 1 meeting minutes. Please carry on. Yes. What else?
Lordship, and then due to some technical problem, it has to be redrafted again, the whole appeal from the beginning. So
How
as
many
I was saying,
computers?
yes,
How many computers do you have in the Advocate
I
General's
have one
office?
laptop, Lordship.
Only
and
one
it
computer?
was- yes, I
Huh?
have one laptop with me, and in that laptop, I have drafted my appeal, Lordship. And even not only this appeal was lost, other appeal which I have already drafted was also lost in that laptop. So I have to reload the Windows, and everything was gone, Lordship. So I have to redraft the whole appeal,
No,
even
this is
other
a-
appeals also.
This is a common
Lordship,
problem
yes.
for everyone. So that is why you should also take precautions when you draft something. Don't leave the entire thing in the computer. Put it in your pen drive, put it in some other storage so that you can recover that. If you just bank on
So I cannot
one
recover it.
device,
So that was the reason why, yes.
if you bank on only one device, you'll face this kind of problem in future as well. So you should learn from that, you see.
That, yes, Lordship,
It's not
that I've known.
if
I've
you're- It's
already
not that
backed
this is
it
your
up.
first case. You've been dealing with all these matters.
And Lordship, in the month of December, it was, yes, I have finalized it. And I was ready for filing the appeal. But however, due to some personal difficulties, some medical conditions, I could not apply it. I could not file it. So winter vacation has come up on,
Okay,
So-
you said medical condition. Where is your statement?
but this is, my statement is on para number, Roman number 9. I have not mentioned it that it is a medical condition, but I have some personal difficulty.
So
It was,
if you say A, you mean B. If you say B, you mean C. Is that how you want to understand
no,
your drafting?
no, Lordship, I'm
Then-
just emphasizing it, Lordship, I'm just emphasizing it. There's some personal difficulty in the part of the present government advocate. So it could not be filed, and moreover, the winter vacation came up, and due to the change in the government also, I could not file it within time. So when it can only be filed in the month of March, Lordship. And then in the meantime, Lordship, the court fees was not furnished by the department. So I have to request the court fees again on 21 to 2022, 2002-23, the court fees was furnished to the government advocate.
2023.
Yes.
I think
Yes,
you're
there
wrong.
was some yes typo within the application.
I think you're wrong.
Yeah, 2024.
24. February 23, you do not even ask. Your file was lost.
No,
So-
Shiva, I apologize. There was some typo in the application also. I've made it 2022. It should be 2024.
See, stakes involved are high. Almost 1 crore.
Yes, Lordship, it was, yes, the department has requested the Advocate General, Additional Advocate General. It was on time at that point of time. There was a 75 days lapse only. It was still on time. But however, due to some misplacement, in the office. It was a bona fide reason, Lordship.
What
And
is the period of limitation?
90 days, Lordship.
90
for
days.
Regular first appeal, yes. It was still within time when they have requested to prefer an appeal. But however, due to misplacement, that letter was never known by the present government advocate that an appeal has to be preferred. So when the status report was asked by the department, she came to know that an appeal has to be preferred. Yes, she has taken some time in drafting and everything, but as I've mentioned it earlier, Lordship, this was not the only appeal. Which
How many government councils are there in the office?
At that point of time, Lordship, I believe it was five.
Five.
Four.
So you always have this kind of communication gap?
Yes, sometimes we have, Lordship, communication.
Why
that
is
we
it
have.
so?
Lordship, that I do not know, Lordship.
You all are staying in one office only.
No, with regards to this misplacement, it hardly happens. But these
No,
two
regarding your
appeals-
endorsement by the Additional Advocate General to you.
No, it hardly happens, Lordship. It hardly happens.
But it has happened.
This is
The other case, the other day
yes,
also that happened in that
cases,
case.
Yes.
Today
yes,
also same
two
thing
cases
happened.
It happens.
Tomorrow you might come
Two
with another
cases
same case.
happens. No, Lordship, it wouldn't be happening again, Lordship. Two cases it happens. I have filed the other appeals also in the month of in this year. It doesn't happen. There's hardly any delay in that. So in this two appeal, in the other appeal which I've mentioned earlier, I've made some delay made by the council also is there involved. So, but it was all due to bona fide reasons, Lordship, that a request was made to the Additional Advocate General, but it was never known by the present government advocate that an appeal has to be preferred. So some delay was made even by the council also. And Lordship, as I've stated in my application, there were some reasons which are beyond control.
What are those reasons which are beyond control? We would like to know.
Lordship, these are the technical problem, Lordship, and the personal difficulty of the council.
Okay.
Yes.
Anything
These were
else?
the reasons beyond control. Yes,
Anything
Lordship,
else?
I'd like to place an authority, Lordship.
Yes, what is that?
Uh, $3,000, Lordship, I'll check it on. Two 2023-10 SCC 531, Shivraj Singh.
Go slow, please. Have you given a list of books?
Yes, Lordship, I've made a citation memo.
Give-
I've placed (2023) Volume 10, SCC 531, and
No,
If
no,
your
not,
lordship permits-
not and. Just go with this case. Which paragraph?
yes, and I would like to read it, if your lordship permits,
Which
from
paragraph? Which
para
paragraph?
number 34.
34.
Yes.
Just 34.
34, 35, 40, and 41.
Yes, read.
They have made an observation, Lordship, in this judgment. The order under challenge in this appeal is dated 21/12/2011. It was rendered at the point of time when decision in Katiji, Ramegoda, Chandramani, KV Ayuma, Lipok Au were holding the field. It is not that the said decisions do not hold the field now, having been overruled by any subsequent decision. Although there have been some decision in the recent past, State of MP versus Berulal is one such decision apart from University of Delhi, which have not been accepted. Governmental lethargy, tardiness, and indolence in presenting appeal within time as sufficient cause for condemnation of delay. Yet, the exercise of discretion by the High Court has to be tested on the anvil of the liberal and justice-oriented approach expounded in the aforesaid decision, which have been referred to above. Para number 35, Lordship.
Yes.
We find that the High Court in the present case assigned the following reasons in support of its orders. Some principles were laid down in this para, Lordship. The law of limitation was founded on public policy, and that some lapse on the part of a litigant by itself would not be sufficient to deny condemnation of delay, as the same could cause miscarriage of justice. The expression sufficient cause is elastic enough for courts to do substantial justice. Further, when substantial justice and technical considerations are pitted against one another, the former would prevail. It is upon the court to consider the sufficiency of cause shown for the delay, and the length of delay is not always decisive while exercising discretion in such matter if the delay is properly explained. Further, the merit of the claim were also to be considered while deciding such application for condonation of delay. Further, a distinction should be drawn between inordinate unexplained delay and explained delay, wherein in the present case, the first respondent has sufficiently explained the delay on account of negligence on the part of the government functionaries and the government counsel on record before the reference court. The officer responsible for the negligence would be liable to suffer a not public interest through the state. The High Court felt inclined to take a pragmatic view, since the negligence therein did not border on callousness. Lordship, I'd like to read on para number 41.
Yes.
Having bestowed serious consideration to the rival contentions, we feel that the High Court decision to condone the delay on account of the first respondent's inability to present the appeal within time for reasons assigned therein does not suffer from any error warranting interference. As the aforementioned judgment have shown, such an exercise of discretion does at times call for liberal and justice-oriented approach by the courts, where certain leeway could be provided to the state. The hidden forces that are at work in preventing an appeal by the state being presented within the prescribed period of limitation, so as not to allow the higher court to pronounce upon the legality and validity of an order of the lower court, and thereby secure unholy gains, can hardly be ignored. Impediments in the working of the grand scheme of the governmental function have to be removed by taking a pragmatic view on balancing of the competing interests.
Yes.
And Lordship, in this case, the delay, the appeal filed by the petitioner herein was dismissed. There's a delay in filing an appeal. There's a delay of 400 and something days, Lordship, in this case.
479 days.
Yes.
79 days.
Yes. And the Union of India, it was filed by the Union of India, and the High Court has
Condone the delay.
allowed, has granted, yes, has condoned the delay, and on being aggrieved with it, the respondent has filed an appeal before the Supreme Court. And the apex court has dismissed this application, Lordship.
Delay was condoned
Saying
by
that
a
the
single
High Court
judge.
has made, yes.
Delay was condoned by a single judge.
Yes, single judge, Lordship.
And was there any appeal in the High Court?
There was an appeal filed by the Union of India, Lordship, in the High Court, and a delay of 496 days. And that was appealed in the Supreme Court.
No,
by
before the
BJP
Supreme Court.
petition. Yes.
Just listen to what I say. Learned single judge condoned the delay.
Condone the delay, yes.
Thereafter, straight to Supreme Court.
Yes.
No appeal before the division
No
bench.
appeal, Lordship, as I've read it. The issue here is that whether the High Court was justified in condoning the delay in presentation of an appeal, Lordship. That's it.
That we've understood from what you've read.
Mm.
I'm seeing that it was placed before which bench? Single bench, thereafter Supreme Court.
No, Lordship.
Then
It was placed before the DB also, Lordship.
that's what I was asking you.
Yes.
Where is that?
It para number 3, starting from para number 3, it would much bigger, Lordship. I couldn't find it, Lordship.
So, this is not a writ petition. This was a LA appeal.
Yes, LA appeal. But however, there was a delay in filing.
No, before you come to the delay part, just listen. It was an LA appeal before the High Court against the decision of the reference court.
Reference court, yes.
LA appeal was filed before the High Court. It was taken care of by the single bench who condoned the delay. So if it's an LA appeal, there is no further LA appeal before a division bench. So there are no different, there was no division bench proceeding.
Yes,
From the
not-
single
not-
judge,
not different bench.
you have the habit of talking while I'm speaking.
Lordship, I apologize.
If we speak together, who will hear who? So, LA appeal was filed before the single judge, and single judge decided to condone the delay of 479 days. Thereafter, the party went to the Supreme Court. So, there is no division bench in the High Court. Straight away from single bench to the Supreme Court. That is because it was an LA appeal in the first instance. Okay, next case.
Next case, I would like to rely upon the same case, Lordship, Lipok Ao.
Lipokaw is,
2005.
no, Lipokaw is already referred here in your judgment.
Yes,
which you,
Lipok Ao is already, yes. In that case, Lordship, I won't be relying any more authority except this 2023. I think it's very clear from here that some principles were laid down and in para number 35. And I humbly pray your Lordship to condone the delay of 686 days delay, Lordship, since there are some merits in the facts of the case, also in the main appeal, also, Lordship.
what is the merit?
The merit is that, Lordship, the respondent herein has filed a civil suit in before the senior civil judge
Yes.
and claiming for rental compensation, Lordship, for occupation of their land by the government from 1983 onwards. So the trial court has allowed their claim and directed the state respondent here, the state appellant herein, to pay the rental compensation from 1983 till the date of the order.
Learned Trial Court has made the assessment.
No, DC has made assessment. The learned trial court directed the government to make an assessment.
So, what is wrong in that? If you have occupied the land, you have to pay rental charge.
No, Lordship, in one of my grounds, Lordship, I have stated that, Lordship, they, at that point of time, all the landowners were paid a compensation at that point of time
By whom?
by the government.
Compensation for what?
Compensation for rental for damage. Lordship,
Rental is just one-time payment. You'll pay once and you'll forget it, or what?
that was a statement made by even the present respondent also, Lordship.
No, what is the concept of rent? It does not recur. Rent does
I
not
don't
recur.
think it's a one-time payment, Lordship, but there was some compensation were paid to the landowners.
What sort of compensation? You have done your research. Tell me what kind of research have you done? One time compensation. What compensation was given?
Lordship, that has not been reflected or mentioned it in any of the documents which I've received, Lordship.
So
In the
what is your
order
ground?
also,
What is your ground of appeal on merit then? Because you have just read this judgment of the apex court, wherein you say that in considering delay, the merit of the claim also has to be looked into. That is why I'm asking you, what is the merit?
taken by even by the plaintiff also, the plaintiff respondent also in the trial court, that saying that all landowners will pay compensation. And even the government has stated that all the landowners were paid compensation. And how come at the later stage this plaintiff respondent has claimed after 28 years he has claimed for compensation, rental compensation, without saying anything, Lordship?
Okay, tell me, was the land acquired
No, the land was not acquired,
then?
Lordship.
What kind of compensation was given then? Was it a rent?
The Lordship, I
Or-
believe there was some settlement between the landowners and the
Yes,
government.
tell us, what is that settlement?
Lordship, that I have a limited information with regards to that. And moreover, that was not the stand, that was not
So,
an issue.
on
in
what
the-
basis have you filed the appeal then?
That it was filed
Is
after
it, is there an
28
appeal
years,
just for the
Lordship.
sake of an appeal? Or there are some merits on the appeal?
There are some merits, Lordship.
So tell me at this stage, what is the merit in your
Lordship,
appeal?
Yes. The plaintiff respondent
Yes.
has claimed that they have the respondent government has the appellant state has occupied their land from 1983, and that all landowners were paid compensation. Please give me compensation also. They have claimed for rental compensation. So, and Lordship, the stand taken by the government is that it was barred by limitation in the trial court. And moreover, the periodic patta holder, that is the father of the respondent herein, has already died, and it cannot be transferred to the present respondent. That was a stand taken by in the trial court, Lordship, and that it was barred by limitation, Lordship. After 23 years, they have claimed the rental compensation. 28 years. And Lordship, as I was saying, this is a second round of appeal. Lordship, during the pendency of the trial, there was some spot verification was conducted, and based on that, the learned senior civil judge has passed an order, judgment and order, saying that the suit was barred by limitation. And the present respondent herein has already filed an appeal before the Honorable High Court on 2016. And there was some observation made by the Honorable High Court that is on my memo of appeal, Lordship, and that it has to be heard afresh, and that the issues have to be decided again as per the relevant law.
Show me that order.
Yes, it's in my memo of appeal, Lordship. It's on page number 40, annexure 4. And the relevant portion is on page 47, para number 7.
Yes.
And yes, the parties were heard afresh, Lordship. But if the Lordship can come to the judgment and order dated 28/1/2022, the learned trial court
Without what?
without any discussion, without any, has misinterpreted the order made by the Honorable High Court, has just decided in favor of the plaintiff respondent herein, Lordship. Issue number 2, that is on Roman number 6 of the judgment and order, the impugned judgment and order. Just because the High Court has quashed and set aside the order dated 26/1/2016, he decided not to further discuss and just rely on the High Court's order.
Yes.
And regarding the periodic patta holder, some discussion were made in issue number 3, but however, there was some confusion by the learned trial court also regarding the periodic patta holder, Lordship. As we have stated in our written statement also, the holder does not have a transferable rights. So the periodic patta holder is the father of the respondent herein. He has already died. Although he has a heirship certificate, that heirship certificate does not specifically mention the periodic pata number also in the heirship certificate. That was my other ground also, Lordship.
What do you say about this observation by the High Court, page 47?
Yes, regarding the title, yes.
Even though there was no specific legal certificate, heirship
Yes.
certificate, appellant in respect of the land in question, the fact remains that the periodic pata issued with the same has continued to be extended from time to time, even after possession of the land was taken by the state respondents. Therefore, prima facie, appellant has a good claim of title and right over the land in question. Prima facie view of the High Court.
High Court.
This remains, isn't it? Have you challenged?
Yes, Lordship, but however, we still take a stand in that. And moreover, based on the question of limitation also, it has to be discussed again. The trial court, in the previous trial court, has dismissed the suit based on the limitation only, question of limitation only. But this observation made by the High Court has been clearly misinterpreted by the trial court, Lordship. If we read the judgment, impugned judgment and order, Lord.
So, besides your stand taken on technical grounds, you don't dispute the fact that you are occupying that land.
Yes, we are occupying that land, and there was some a building was constructed, a polytechnic was constructed in
Okay,
that
and you said some payment was made also,
Some payment was made to other landowners,
not the instant
not
respondent.
not the instant respondent.
Then
And no claim was made by him.
we are concerned with the instant respondent. We are not concerned with others. You forget about others. What about this present respondent?
Then present respondent did not make any claim within from 1983 till the filing of the suit, that is 2012.
Okay.
And on that suit, they have claimed rental compensation.
All right. Anything else?
No, Lordship. And I pray this honorable court to condone the delay of 686 days, Lordship, for in the interest of justice, Lordship.
Okay.
And since there is a merit in the case also, Lordship, the state have to pay rupees 83 lakhs to the present respondent in spite of the limitation that the suit has been barred by limitation, Lordship.
Okay. Yes, Mr. Joseph.
My lord, with respect to the merits of the case, even though I'll not go into the merits because I don't have the brief, they have not been supplied with the case file with today. But my lord, as far as I can remember, because I was appearing in the first appeal, my lord, what had happened at that time was, I'll just give your lordship a clarification of that case. Initially, a suit was filed, like my learned friend had mentioned, my lord. The suit was dismissed on the ground of adverse possession, my lord. My lord, adverse possession means you accept that this person has the title, and then after that, you occupy the land, and that person has not filed a suit for 12 years. Then you become adverse. The suit becomes adverse. The suit land becomes adverse. And based on that, the court dismissed the case, my lord, adverse possession. So an appeal was filed in this court, and this court remanded the case back to the trial court, my lord. So that adverse possession has been taken away, my lord. And one thing I would like to point out, my lord, with respect to the merits of the case, first of all, that periodic pata, my lord, this is the instruction I received just now because I was asking the client as we were having this hearing, my lord. So after that case got remanded back to the district court, to the senior civil judge, the periodic pata, my lord, has been extended again, my lord, and it is valid today till December 2024. So what we are seeing, my lord, is the respondents, the revenue departments, who are the respondents number 5, 6, 8, and 9, my lord, they have continued to accept the validity of the periodic pata. So on merit itself, my lord, firstly, they have continued to accept the validity of the periodic pata, my lord. And secondly, my lord, when the judgment and order was passed, we have the respondent, the applicant number 2, applicant number 7, and applicant number 10, my lord, who have taken steps. The applicant number 2, 7, and 10, they have taken steps to pay the compensation to the applicant. My lord, the first is the district commissioner. If your lordship will come back to their application, my lord. The first is the deputy commissioner, page number 34, my lord. Page number 34. This was a letter sent by the deputy commissioner to the secretary to the government of Mizoram, higher and technical, my lord. Now here it says, my lord, sir, in compliance with the judgment and order dated 28/1/2022, passed by the senior civil judge Lunglei district, Lunglei, the rental charges in respect of Vanal Dongliana's land covered under periodic pata number 230 of 1976, occupied by the Mizoram Polytechnic, Lunglei, Rangchal Kon. My lord, here also he has admitted, covered, and they have occupied. There is no dispute. He has not disputed. Total amounting to so and so. Only is assessed as per the judgment and order. So the deputy commissioner, my lord, has made an assessment. It means he has no dispute with that judgment and order. He has plainly accepted, my lord, that there's a periodic pata and they are occupying that periodic pata. And page number 33, my lord. This is a letter to the director, higher and technical, by the principal, Mizoram Polytechnic, Lunglei, my lord.
Yes, we have seen all these.
Yes. So what I am trying to say, my lord, is, and finally, my lord, page number 36 is the letter by the director to the undersecretary. So all of these parties, my lord, first of all, the revenue department and the higher technical, my lord, they have taken steps for compliance with this judgment and order. My humble submission, humble understanding at this stage, my lord, is they were not disputing this judgment and order. Now, finally, they filed this judgment and order, my lord, after many months. And in this respect, my lord, I have my... So on merit itself, my lord, they have sort of they have not objected, they have accepted, they have taken steps in compliance with the judgment and order. Even though I don't have the case file with me today, my lord, on merit, I don't know what they are suddenly disputing. It's only on the basis of that meeting, and that meeting provided no
Come
grounds.
to the meeting,
Yes.
page 37.
37.
Just read the chairman.
The chairman, P.S. Sarlalwat Kimi, IRS Commissioner and Secretary, Higher and Technical Education Department, welcomed the members. Thereafter, representative of the Law and Judicial Department explained the implications of judgment and order dated 34/4/2021 on civil suit number 1 of 2012, and the meeting had discussion on the issue as well as the viable way for filing an appeal in the case. After thorough discussion, the meeting decided that an appeal be preferred against order dated 23/4/2021. For this purpose, a certified copy of the relevant judgment order, IBIT, may be obtained from the concerned court, and the government advocate of the case may be informed to draft an appeal memo and take all necessary actions for filing of the appeal within the stipulated time frame. The government advocate shall immediately submit the draft appeal memo to the Commissioner and Secretary, HNTED, for onward obtaining of vetting from the Law and Judicial Department accordingly. So, only after this meeting, my lord, they decided to file this appeal. Until this meeting, my lord, they had appeared to have accepted this judgment order, except, of course, the secretary, my lord, because a letter was sent to the secretary. Once the letter was sent to the secretary, my lord, this meeting was convened. Until then, the DC was there, the principal, Polytechnic, Higher and Technical was there, the director was there. Then the Land Revenue and Settlement Department, they continued to extend the periodic pata. So in that view of the matter, my lord, on prima facie, this is my submission, my lord, on prima facie understanding of these entire circumstances, even though I don't have the appeal memo with me, my lord, it appears that on merit, there is no dispute with respect to the ownership and title of the plaintiff. And my lord, that appeal, that judgment of the High Court also, my lord, was never appealed, even though those observations were made. Observations that on prima facie, this person has the title and ownership, my lord, they have not filed any appeal against the judgment order. So that is the first, my lord. On merit, I'm just trying to give your lordship my submission on the merit of the case, because my learned friend was trying to rely on the merit of this case, my lord. Now coming to the delay, my lord, if your lordship will come to the objection we have filed, my lord, at page number 3. My lord, I will read out our objections from A. It is mentioned by the applicants at subparagraph number 4 of paragraph 1 of their delay application that the concerned department has requested the learned additional advocate general to prefer an appeal via letter dated 12/4/2022, and that on the same day the matter was endorsed to the government advocate for filing of appeal. However, no step was taken by the concerned government advocate to file the appeal. Interestingly, the concerned government department had also not made any inquiry from either the additional advocate general or the government advocate regarding the status of the appeal. They made the inquiry only on 16/5/2023. On inquiry, the government advocate searched her office to locate the documents but could not find the same. This shows that the appellants were not at all diligent. Indeed, it shows that there was gross negligence on their part. It was because they were not diligent that only on 7/6/2023, that is after more than a year, it came to the notice of the concerned department that the file was misplaced. Until that time, they did not seem to make any inquiry. By that time, there was already a delay of 495 days in preferring the appeal. Apparently, no reason was given for the 495 days of delay, my lord. So this is the first objection, my lord, that 499 days, my lord, they waited for the government to file appeal, my lord. We all know, my lord, the government are aware, my lord, that in order to file appeal, you need to go and sign in affidavits. One representative has to go to the High Court. Then as per the meeting minute, the vetted documents have to be sent to the Law and Judicial Department. They have mentioned all of that, my lord. They know the procedure very well. But they waited for 495 days. Then B, my lord. It is also mentioned at subparagraph number 7 that the drafting of the appeal began in July 2023. However, as it appears, no finalization of the appeal was done immediately, even though a significant number of days had already occasioned by that time. It is evident that no urgency was shown by the appellants in preferring the appeal. After a significant period of 3 months, that is October 2023, it appears that the so-called drafted appeal was again found to be lost. Interestingly, the appellants did not try to give any explanation at what had transpired between July 2023 to October 2023. In other words, they did not explain why the appeal was not finalized during the said intervening period. C, it is also mentioned at subparagraph number 8 and 9 that though the appeal was redrafted and finalized in December, no explanation was made for the period between October 2023 and December 2023. It is hard to imagine that the appeal was drafted for that many number of days. Furthermore, no mention is made of the day the said appeal was finalized. Apparently, the concerned department also did not make any inquiry regarding the appeal. It is mentioned at subparagraph number 9 that though the appeal was finalized in the month of December, the appeal was not filed as the concerned government advocate had some personal difficulties. No hint was given as to what difficulty the concerned government advocate was facing. Furthermore, no explanation was given as to why the others working the same office did not file the appeal, especially since there was already a significant number of delays by that time. It was also mentioned at subparagraph number 9 that there was a winter break and that after the winter break, the appeal was going to be filed on 14/2/2024. It was found that the court fees were not furnished to the government advocate on 14/2/2024. A request was made and that on 21/2/2024, the court fees were supplied. However, in this respect, it is pertinent to note that after the winter vacation, the courts had reopened on 12/1/2024. Considering this fact, it is incumbent on the appellants to explain the reason for not filing the appeal immediately after the winter vacation and why they waited till 14/2/2024, especially since the appeal was already finalized in December 2024 before the winter break. It is also mentioned at subparagraph number 9 that though the court fees were received on 21/2/2024 by the government advocate, the appeal was only filed in the month of March 2024. Again, no explanation was made for the period between 21/2/2024 and the date of filing of the appeal in March 2024. And my lord, paragraph number 5 is important because they had not mentioned this fact. At this stage, it is humbly brought to the attention of the court that after the impugned decree was passed, the opposite party had filed an execution case bearing execution case number 4 of 2023 in the court of the senior civil judge, Lunglei District, Lunglei, Mizoram. After the execution case was filed, the learned senior civil judge passed an order dated 24/1/2023, by which order notice was issued to the present appellants. After several orders were passed in the said case, on 25/1/2024, the executing court passed an order dated 25/1/2024. The said order is reproduced as follows. The learned counsel for the decree holder is present before the court. The case is listed for submission of list of properties sought for attachment. However, on perusal of materials on record and on due consideration of the nature of the case, this court deems it fit to proceed with Order 21, Rule 41 of CPC and the judgment debtor number 10, is hereby directed to appear before court for filing of affidavit stating the particulars of the assets of the defendants. That on the next court date, that is 23/3/2024, the judgment debtor number 10 was present in the executing court. A declaration affidavit titled Additional Affidavit dated 23/2/2024 listing particulars of assets was filed that day. However, since immovable properties were not listed in the said declaration affidavit, an order was passed whereby another date 27/3/2024 was fixed for filing a list of immovable properties. That from the above facts, it is evident that the appellants had actively participated in the execution proceeding. Thus, it cannot be denied that they were aware of the fact that the appeal was not filed by the concerned government advocate, even after a direction was made for attaching the properties. In spite of the same, there is nothing to show in their delay application that they had made endeavors to instruct the government advocate to urgently file the appeal. Indeed, they also did not seem to make any proper inquiry from the government advocate. It thus shows that they were negligent in their approach. They appear to have woken up from their slumber only after the executing court had passed the order for attachment of the immovable property. But also they knew all along that it was not filed. And my lord, I have judgments to cite in this case, my lord. The first judgment is a judgment of this honorable court. This was passed in IEA number 133 of 2023, my lord. This was authored by Justice Robin Pukan, my lord. I will not read all of the relevant portions because the relevant portion starts from paragraph number 10, my lord. He has highlighted the entire position of the law on delay application. But the relevant portion, my lord, will start, I will read from paragraph 15 onwards, my lord. Page number 13.
Yes.
Paragraph 15. The legal position, which can be crystallized from the aforesaid discussions and discussion, is that courts are not supposed to legalize injustice, but are obliged to remove injustice. Therefore, liberal, pragmatic, justice-oriented, non-pedantic approach has to be adopted while dealing with an application for condonation of delay if sufficient cause is being shown. The term sufficient cause can be understood in their proper spirit, philosophy, and purpose, and regard being had to the fact that these terms are basically elastic and are to be applied in proper perspective to the obtaining fact situation. The paramount and pivotal consideration is substantial justice. The technical considerations should not be given undue and uncalled for emphasis. In respect of deliberate causation of delay, the presumption is not available, but gross negligence on the part of the counsel or litigant is to be taken note of. Besides lack of bona fides imputable to a party seeking condonation of delay, which is a significant and relevant fact, the courts should not adhere to strict proof but required to be vigilant so that there is no real failure of justice. The approach of the court must be liberal, at the same time it must be reasonable also. In case of inordinate delay, strict approach is to be required. My lord, in this case I was reading, it was 488 days. The court took a strict view, my lord. 488 was considered to be an inordinate delay. Strict approach is required to be taken, while in the case of delay of short duration, a liberal delineation is required. The fundamental principle being weighing the scale of balance of justice in respect of both parties, and the said principle cannot be given a total go-by in the name of liberal approach. While condoning the delay, the conduct, behavior, and attitude of a person, of a party relating to its inaction or negligence are relevant factors to be taken into consideration. In the case of the explanation being offered is concocted or the grounds urged in the application are fanciful, the court should be vigilant not to expose the other side unnecessarily to face such litigation. The entire gamuts of facts are to be carefully scrutinized, and the approach should be based on the paradigm of judicial discretion, which is founded on objective reasoning and not on individual perception. The state or a public body or an entity representing a collective cause should be given some acceptable latitude, but the law of limitation is same for citizen and for government authorities. Now, my lord, paragraph number 17. It appears that the learned senior civil judge, Kolosip Mizoram, has passed the judgment and order and decree dated 1/4/2022 in damage suit number 6/2019 and period of limitation for filing of appeal till 30/6/2022. But the same could not be filed, and it was filed only on 2/11/2023. With some explanation for the delay, it further appears that earlier, one Mr. Ali Hussein engaged counsel for the railway was conducting the case, and thereafter the central government. My lord, I'll come to paragraph 18. This is where it's relevant, my lord. The grounds so assigned for the delay appears to be not at all satisfactory. There was lapse on the part of the applicants in taking a decision to file an appeal, and thereafter, my lord, handing over the file to the CGC. However, after handing over the file to the CGC, the learned CGC has misplaced the file and could not trace out the same. And only in the last week of August 2023, and thereafter the mother of the present CGC suffered demise, and on account of funeral and other related rituals of the mother, he could not prepare the draft till 2/10/2023. My lord, based on this, the court said this explanation was not satisfactory. In this case, it was also misplaced, but there was a delay of only 488 days, my lord. In our case, it's 686 days. So it's an inordinate delay, and strict approach has to be taken, my lord. And I'll also cite one other judgment which was passed by your lordship. This was in IAS Civil number 94 of 2024, my lord. My lord, in this, I will only, because your lordship had also considered the importance of inordinate and unexplained delay. I'll not read everything, my lord, but if your lordship will come to page number 13, my lord. Page number 13.
Yes.
On the 9th line. Sorry, I'll start reading from the 5th line. However, as already observed earlier, the applicant has failed to explain with relevant materials as to when the judgment and order of the lower court was forwarded to the regional headquarters at Shillong for further steps, and also what transpired within the organization with supporting materials between the second week of August 2023 and 29/11/2023. Therefore, the instant case also falls under the category of inordinate and unexplained delay, and thus detrimental to the applicant. My lord, in this case, the explanation from second week of August 2023 to 29/11/2023 was not given. In our case, my lord, there was an unexplained delay of so many days, my lord. 495 days was not explained in the beginning. That was never explained. After the case was forwarded to the government advocate, no inquiry was made. What transpired inside that office was not explained. Then also, my lord, there were many unexplained delays, as I had mentioned already, my lord. So my humble submission, my lord, because this is an inordinate delay, strict approach has to be taken, my lord. So on these grounds, my lord, my humble submission is that the delay should not be condoned.
All right. We'll come back
Yes, my lord.
in 5 minutes.
Lordship, item number 10 has been running on for quite some time. Mr. Shiata is available.
Okay,
If the Lordship
so
permits.
let me pass, okay. So we'll do one thing, see, I'll pass the order in chamber, this matter, okay? You show it as disposed. This book also.
Item number 7 for admission.
Lordship, before proceeding, Lordship, I'll just like to place one more citation.
What is that?
2019, volume 10, SCC 408, para
2009.
number 10.
Say it slowly,
Yes.
we have to write it down also.
2019.
Unless you give a
volume
list of
10,
books. 2019,
Volume 10,
uh,
SCC 408, page 408.
you've taken 600 days to file an appeal. You want to finish your submission within 5 minutes.
Lordship, I apologize.
Paragraph?
State of paragraph number 10.
Paragraph number 10. You want to read it?
No, Lordship, it's a short para.
This is 44 days delay.
No, with regards to the delay, there is 313 days delay, Lordship.
State
In
of
this
Manipur
judgment.
versus Koting Lamkang.
Koting Lamkan, yes.
Paragraph 10 reads like this. In the present matter, the delay to the,
Yeah.
okay.
Yeah, in moving to the wrong
Moving,
court.
okay.
Yeah, yes.
Now, okay. Then the total days was how much?
312 days.
312 days. All right, yes. Okay, we'll consider this also. All right.
Deeply obliged, Lordship.
Item number 7.
Lordship. In the meantime, the petitioner has been given his running bill in respect of the work which has been allotted to him.
Okay, so
Lordship, may I have a copy? The agreement amount is 2,30,40,000. And from that, the amount has been reduced to 107.52 lakh. That is 46.4%. And now the work that has been completed so far by the petitioner had come to 1 crore 3,19,134. Lordship may see at the third page.
third page.
Third page, Lordship. Net value of work or supply since previous bill. And out of that, some deductions have been made in the last page, running account bill, 7% and 2% GST, 7% security deposit, and 1% labor cess has been deducted, and the amount that has been paid to the petitioner had come to 93 lakhs 18,704. So this is running accounts bill. It's not a final bill.
So why is it listed today?
Your Lordship, they have not filed the affidavit also.
If
the
I may, my
respondents.
lord. In terms of the last order dated 16/8/2024, my lord, I was asked to produce the GCC, my lord, General Conditions of Contract. I have not been provided the same, but however, there's a special conditions of contract clause, my lord, in which there's an arbitration clause, my lord. So if your lordship can grant me a week's time in order to produce the same, my lord.
In fact, Your Lordship, the petitioner ought to have submitted this document, but because of the urgency in filing the connected writ petition, Lordship, that portion of the contract, agreement GCC has been omitted. So we can furnish that also. But if he's filing affidavit, I think that can be.
What is your prayer in the writ petition?
My prayer is that
To allow you to work as per the original
yes, original the
amount which
agreed-
was.
yes. As part of the agreement, Your Lordship. Till date, we have been allowed to execute some portion of the work to the extent of 10109.
What is that 109?
That 109 is
Have you completed the
103. 103. 103 lakh 19,134.
what is
Have
that?
not- Yes.
What is that? The original agreement?
No, it's so far the work that has been completed, that has been billed as part of this running account bill,
See,
and which has been paid to the petitioner.
the original work has been reduced to 46.4%.
Yes, Your Lordship.
Have you completed that?
I have not completed to that extent. I have completed to
What is-
the extent of 103. Some little portion has not been completed so far as that 107 is concerned.
But from where you're saying that 106, 107?
107 is at page 68, Your Lordship. Page 68. At the bottom, serial number 7, under C. Construction material airfield to Muthilui and Zokosang Agricultural Link Road. The original sanction amount was 240 lakh, and the expenditure sanction was given 128 lakhs, and from that the revised expenditure sanction was made to the extent of 107.52. That has come to 46.4% of the original contract work. Out of that, I have completed the work, and I was given the bill of 103 19,134 as part of this running account bill.
So what remains is 107 minus 103.
Yes, as part of this revised estimate expenditure sanction.
And how long will that take?
That will not take long. It is in the process of completion now. We have this bill was submitted.
So you've got your bill,
Yes.
Only a little bit of work remains after it was deducted. It was after it was reduced.
This measurement was made on 16/5/2024.
May.
Yes, 16/5/2024. And the third page, Your Lordship, in the middle of the page, Your Lordship will see. The measurement were made by Christopher Ramnun Moya, JE, on 16/5/2024. By this time, I think even the remaining portion
Might have been
yeah,
finished.
might have been.
So why was the additional AG required to produce this GCC?
Your Lordship,
Is it because
Of the
that there was
arbitration
a alternative dispute redressal forum in probably in the GCC or whatever conditions are there? That was
that
because of
condition
that.
is there, yes.
Because of that, he was asked to produce that.
Yes, Your Lordship.
So that you may be considered to be relegated to that forum.
Arbitration.
Let them first file the affidavit, Your Lordship, if that is necessary.
Can you also file your GCC?
Yes,
You have the GCC with you.
I have, yes.
You are saying that there's no GCC?
I said there is, my lord, special
What is that?
conditions of
Huh?
contract.
Sorry?
There's a special conditions of contract under which there's an arbitration clause, my lord.
So what is
Wherein
it?
in case of any disputes, the parties are to address the arbitrator, my lord.
I understand.
Yes, my lord.
He says GCC, you say SCC.
Yes, my lord. There's a special conditions of contract. When the agreement
Special condition of contract is part of GCC.
Okay, in the
But,
GCC.
yes,
in the
itself.
GCC.
Oh, okay, okay. Please write Mr. Silaram Zhao, Lanet Senior Counsel, assisted by Miss. Your good name, Madam? Dalrot Sami, IPS for the petitioner, while Mr. Samuel Bangladesh Sangte, Learned Additional Advocate General, appears for the state respondents. Next para, by producing the running account bill for measurement which was done, for the measurement of work which was done as on 16/5/2024, the Learned Senior Counsel submits that a bill for an amount of rupees 103,19,134 was raised, and out of which a sum of rupees 93,18,704 has been disbursed to the petitioner after making the required deductions. To stop, he submits that since the work has been reduced, only up to 46.4% of the original work to be undertaken by the petitioner. Not comma, which works out to rupees 107.52 lakhs, comma, the balance work remaining is quite minimal as on today. Stop. He submits that due to the urgency, the petitioner could not file the general conditions of contract bracket GCC along with the writ petition. At the time of filing the writ petition. And he therefore prays that the petitioner may be allowed to bring the same on record by way of an additional affidavit. Stop. The prayer is allowed. Next para, Mr. Samuel Banarsi Sangtel, an additional AG, submits that as per the special conditions of contract, which is also a part of the GCC, there is an arbitration clause for resolving the disputes. And that the petitioner, without exhausting the said remedy, has approached this court in filing the writ petition. Post up, he otherwise submits that he may be given how much time?
2 weeks, Madam.
2 weeks time to file counter affidavit. Stop. The prayer is also allowed. Next para, in view of above, list the matter again. After 2 weeks, respondents to file their counter affidavit, and the petitioner may file an additional affidavit incorporating the GCC. What about this bill? You'll take it back?
Sorry. Yes.
Obliged, Madam.
For hearing, item number 12.
Yes.
My lord,
Okay.
we tried to contact the respondents, but we could not get their response.
You are for the appellant.
Yes, my lord.
You tried to contact whom? The council?
Yes, my lord.
Who is the council?
It's Samuel L. Pachwa.
Okay. But his name is shown in the cause list, isn't it? He should appear before the court.
And my lord, regarding this matter, the BC verdict has been called upon, and it appears that it has already been received here.
BC.
Yes, my lord.
Which record was called? Village Council?
Yes, my lord.
Of which place? Just show me where that record. BC Court.
Kannala Nagar,
District Council.
Chakma Autonomous District, my lord.
Have you seen the file?
My lord, we haven't received the order yet, but when we went through the case file,
No, you haven't received which order?
the verdict
Of?
of the local council.
Then how did you file the appeal?
My lord, it was called upon.
Huh?
It was called upon. It was called on 22nd 11/2023.
Called by the court?
Yes, my lord.
No, that is why I'm asking you, has it reached or not? You said it has reached. Then I've asked you whether you've seen it or not. What is your answer to that? Have you checked up these files?
Yes, my lord.
Are the records available?
Yes, my lord.
This is what I want to know. This one record is from the Judicial Officer, District Council Court, CIDC.
Yes, my lord.
This contains the complaint by the wife.
Yes, my lord.
And what is this? The verdict.
The verdict, my lord. The verdict of the
And the
village
statement.
council. And the statement, yes, my lord. So, in the previous court, it was called upon, and then thereafter.
And what is this file?
Once the verdict has been received here, then we could perform the hearing.
No, you have to assist the court, not by just submitting like that. You have to also check the records, whether the records are available or not, because You have your right to check the records once it's listed before the court. You can always go through it to see whether it is there or not, whatever materials is required by the court. What is the case number before the VC court?
My lord, there was actually what happened is there was a VC verdict, first of all.
Was it registered as a case number with case numbers?
The case number was, one second, my lord.
There is no case number.
There's no case number.
Then, after that, it went to the district council court.
Yes, my lord.
So, was it numbered?
Was it? Yes, my lord.
What is the
It's,
number?
Reference case number 29 of 2019.
Okay. And what was the verdict?
The verdict was to pay the maintenance, and since the complainant and the respondent, they were not married, but the judgment and order clearly passed the judgment of being married, such and such.
So, what are you challenging? The order of the village council court or the order of the district council court?
District council.
Okay. What is the issue initially?
The issue is that whether the appellant court was right in granting the reliefs which were not paid in the original complaint, dated 19/11/2019.
Oh, that's a different thing. What is the issue on facts?
My lord, there is a substantial questions of law.
Oh. What is the story behind this case?
The story behind is that
Dispute between husband and wife?
husband and wife, my lord.
So, the wife submitted a complaint?
Yes, my lord.
For what? For divorce?
For divorce.
And was it granted?
She complained that the husband have extra affairs with another woman,
Okay.
such and such.
And so?
And so she complained to the local council.
So, what was her prayer?
So the prayer was that to give the maintenance and as well as the divorce.
Maintenance and divorce.
Yes, my lord. But then they were not married as per the customs. They were not married, they were in live-in. But the verdict was that they have given the divorce. So in our prayer, it is, we mentioned that whether the appellate court was right in granting the...
See, in the Honorable Village Council Court of Kamalanagar 1 declared that from today onward, they will live together in the same house and cannot meet each other. Huh? They live in one house but will not meet each other. So it was a big house or what? If anybody be found mentioned above, do you have the order?
Yes, madam.
If anybody, just read the last part.
If any of the party is not satisfied with the decision of theirs,
No. What are you reading?
my lord,
Read the verdict of the village council court. Is it available in your pleadings? In your appeal?
it is, my lord. One sec. In the Honorable Village Council Court of Kamalanagar, I declare that from today onwards they will live together in the same house and cannot meet each other. If anybody be found mentioned above, Village Council Court cannot take any legal actions against Subhash and Swapna as per the Chakma Custom Law Code in 1997.
So what do you understand by that?
My lord, regarding this, they have tried to reconcile the situation, but they could not live together. One is saying, I've tried to call her back, and one is saying he is not calling me back, so and so. So the matter went up to the district court.
No. I'm asking you, what do you understand by this order? This sentence which you just read? How do you implement this order? A declaration has been made, correct? Both of them will live together in one house, but they will not meet each other. Then secondly, if anybody found mentioned above, what?
Village Council Court cannot take any
There's something written here. If anybody be found mentioned above, what is this? What do you have, a typed copy or a handwritten?
type copy.
The handwritten copy is here. There's some addition here between above and village council. If anybody be found mentioned above so and so, village council court cannot take any legal action against of
Above points, I believe, my lord.
okay points.
Yes.
If anybody be found mentioned above points, but what does it mean?
It's quite complicated. Thereafter, the
Village council court
the wife
cannot take any legal action against of so and so as per Chakma. What do you understand by this order? The village council court wants to bring them together to stay in one house, but not to meet with each other. Then it's beyond my understanding. Anyway, come to the appeal now.
Yes, my lord.
What does the appellate court say? Can you just read the brief facts of the case?
Yes, my lord.
Just read.
On 3rd 9/2019, the appellant, Sapna Chakma, filed a petition before the village court of Kamalanagar against her husband, B.K. Subhash Chakma, alleging him to be in the illicit affairs with other women and torture her both physically and mentally. However, the said village court did not accept her petition, citing the reasons that the parties were not enlisted in the voter list of the concerned village council. Thereafter, on 19/11/2019, the appellant filed another petition to the village court of Kamalanagar. The village court of Kamalanagar in collaboration with the presidents of village council of Kamalanagar and Bora Pansuri tried the case on 15/12/2019, and direction was given to the parties to live separately as parties did not solemnize marriage as per the Chakma custom. And apart from that verbal direction was also given to the parties. On being aggrieved with the decision of the said court, the appellants Sapna Chakma on 23/4/2019 appealed before the district council court against the verdict of the village court. The appellant alleged that the village court has decided the matter of their family dispute without following the principles of natural justice.
Just pause there for a moment.
Yes, ma'am.
Out here it's written that the direction was given to the parties to live separately. But it says they will live together in the same house. Is it not contradictory? And yet they cannot meet each other.
They will live together in the same house and cannot meet each other.
Okay, anyway, so you come to paragraph number 2 now.
The appellant has mentioned in her petition that divorce was granted without considering her claims. The custody of the children was given to her and their property.
Who's the appellant? The wife.
The wife.
Okay. Divorce was granted without considering her claim. Who gave divorce? Nobody gave divorce.
My lord, that is the matter which it's the question of substantial law. So without being married, they were given divorce, such and such.
Who gave divorce in the first place? You just read the order of the village council court. Does it say divorce?
My lord, I'll come to that. Here in the verdict, it clearly states that in the Honorable Village Council Court of Kamalanagar, heard both statements, husband and wife, and found it both are guilty because they are not married accordingly to the Chakma customary system. And
From
due to
where are
that-
you reading?
My lord, the verdict,
Which part?
second paragraph.
So the sum and substance of the verdict is that they were not married as
Yes,
per
my
the
lord.
custom, and they could not produce any marriage
My lord,
certificate.
actually this verdict will be in our favor because they were not married.
Whatever it may be, I'm not asking, I'm not saying that it should be in your favor, their favor. We're trying to understand this order, the verdict. The verdict says that since both are not married, as per the customary law,
Yes,
this-
my lord.
the village council court cannot grant any such kind of divorce. Anyway, they will live together in the same house, but they will not meet each other.
Meet each other.
All these things have been said.
Yes, ma'am.
Now, if you read the appeal order, it says that the appellant has mentioned that divorce was granted without considering her claims. There is no proof as per the Chakma customary law in 1997 that they are married. This village council court never granted divorce. So what is the appellant or the wife saying to the court, district council court? Appellant has mentioned in her petition that divorce was granted without considering her claims. The custody of the children was given to her and their properties were divided. Then what is the ultimate finding? Appellate court has written detailed order. You are for the wife or for the husband?
Husband.
Husband.
Yes, my lord.
You filed this RSA.
Yes, my lord.
What is your grounds of appeal?
My lord, if in my petition page number 9, if I may read out. The appeal is,
Read.
yes, para number 2, Roman number
From
2.
the paper book or from your appeal?
From my appeal, my lord.
Page 9.
Yes, my lord.
Yes.
Roman number 2, my lord. For that, the appellate court travelled beyond the prayer of respondent, herein who originally submitted complaint to the village council court of Kamalanagar. As already stated, she prayed to the Honorable VC court and elders of the village to save her life along with her children, and such prayer was clearly seen in the complaint dated 19/11/2019. The appellant court could not grant the relief beyond what had been originally prayed, as the prayer was for saving their life from the torture, if any, which they alleged to receive from the appellant herein. Hence, by the impugned judgment dated 12/6/2020, the court inter alia granted a divorce and distributed the acquired properties, which is quite arbitrary and unreasonable. As such, the same is liable to set aside and quash. My lord, if I may read further.
Yes.
For that, the learned appellate court granted decree of divorce despite having no valid marriage between the parties. As such, there could be no decree of divorce in such situation where there has been no valid marriage as per the Chakma Customary Law Code 1997. If I may read further, my lord, for the learned appellate court, by passing the impugned judgment dated 12/6/2020, mixed up the case in as much as the reliefs granted were civil matters. However, as per paragraph number 21 of judgment, it was stated that disobedience of the order shall be dealt with the provisions of section 125 clause 3 of CRPC 1973, and hence the impugned order dated impugned judgment dated 12/6/2020 is liable to set aside and squash.
We'll do one thing. We'll
Yes,
post
ma'am.
this matter after the vacation.
Yes,
Let-
ma'am.
Let the other side also come.
Yes, madam.
Please write down. Mr. Ricky.
Yes, madam.
What is your full name?
J.H. Ricky Lalrotfela.
Mr. J.H. Ricky Lalruatfela
Yes, madam.
appears for the appellant. But your name is not in the cost list.
Yes, my lord. Actually, the thing is, since the respondent didn't appear, so the leading counsel was here, but he got some urgency. So he said if some matters come up, if he doesn't show up, then you just pray the court that if it may be listed after the vacation.
You're not engaged in this case?
Yes, during this time, yes, my lord.
Huh?
Yes, my lord.
But you have submitted so much. You have told me. Mr. J.H. Ricky, so-and-so, learned counsel appears on behalf of Mr. Tulan Siyama, learned counsel for the appellant. Stop. However, no one appears for the respondent. Stop. It is seen that the requisition from the village council concerned and the district council court concerned has been duly received. List the matter again after the ensuing vacation. For hearing, last part. After the vacation for hearing. On a date to be fixed by the registry. Is that it?